News of the week is the United States Supreme Court ruling in the West Virginia versus Environmental Protection Agency case. And the ruling is following. Congress did not grant the Environmental Protection Agency in Section 11 of the Clean Air Act the authority to devise emission caps based on the generation shifting approach the agency took in the Clean Power Plan. Good morning, I'm Mate from the Environmental Perspectives and welcome to the Environmental News. This ruling is seen as a major defeat in the fight against climate change. But what does it mean? What's the background and what are the consequences? So let's start with the Clean Air Act, enacted during 1960s and 1970s. It's one of the United States' first and most influential modern environmental laws. But many areas are undefined and therefore left to the Environmental Protection Agency, EPA, to develop more detailed regulations. Later it became apparent that this law is not enough to address the challenges posed by climate change. As a result, there was a legal case of State of Massachusetts versus EPA in 2007 with the following Supreme Court ruling. Greenhouse gases are air pollutants, and the states may sue the EPA if it fails to properly regulate these pollutants. That means that EPA had powers under the Clean Air Act to regulate and address greenhouse gases and climate change. However, the decision didn't say exactly how EPA would do that. Therefore, Obama administration in 2014 and 15 proposed the Clean Power Plan aimed at addressing challenges posed by climate change. The goal was to reduce the carbon dioxide emissions from electricity generation by 32% by 2030. It included two main approaches. First one, to upgrade existing power plants through technologies like carbon capture, carbon sequestration, and conversion of coal power plants to operate with natural gas. And second one, switch to renewable energy sources, the approach that will later be called a generation shifting approach. So basically what this means is that EPA would set fixed reduction targets and then the individual states would be free to choose the approach and methods in how they wish to approach those and achieve those targets. However, many states and companies sued the EPA, stating it has no authority to make such proposals. And in 2015, both Congress and Senate rejected that approach. Finally, it all stopped in 2016 with Trump administration. With the Trump administration in 2016 came the Affordable Clean Energy Rule. The goal was to reduce the carbon dioxide emissions from electricity generation by only 1.5% by 2030. It was seen as a major support to the fossil fuel industry, especially coal power plants. Biden administration, which arrived in 2021, was expected to regulate emissions more strictly. However, they did not continue with the Obama's Clean Power Plan, and generally the approach to power plants is not very clear. Here we reach the West Virginia versus EPA case in 2022. 19 states and some corporations raised it, and it resulted in the following Supreme Court ruling. Congress did not grant the Environmental Protection Agency in Section 111 of the Clean Air Act the authority to devise emission caps based on the generation shifting approach the agency took in the Clean Power Plan. But what does it actually mean? Well, from my perspective, there is a positive side and there is a negative side. On the positive side, Environmental Protection Agency can still regulate emissions at individual power plants by requesting the implementation of the emissions reduction technologies as they have done in the past. However, the cost of those technologies must also be included in each EPA's assessment. Eric Schaffer, Executive Director of the Environmental Integrity Project, said the following. Mandating coal plants to maximize their efficiency could reduce greenhouse gas emissions by 10 to 15%. But on the negative side, this ruling denied the EPA the right to limit emissions at the state level by capping emissions and initiating a switch to renewable energy sources. Here are some of the explanations given by Chief Justice John Roberts. Capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal may be a sensible solution to the crisis of the day. So he actually acknowledges that proposed measures make sense. But he says further, at bottom, the Clean Power Plan essentially adopted a cap-and-trade scheme or a set of cap-and-trade schemes for carbon which Congress has consistently rejected. So he points out that this approach is something that both Congress and Senate rejected in 2015, and whether we like those decisions or not, Congress and Senate are legislative bodies in the United States. So further, he follows. This goal of the former Clean Power Plan to move us away from heavy reliance on coal and fossil fuels toward renewables was far too sweeping beyond what they saw the statute allowing. So he emphasizes that the EPA has no right to interpret the Clean Air Act in such a broad way. So it's up to Congress to make that decision. However, due to bipartisanship, it's very unlikely for any similar act to be enacted soon. So basically, there is a reasonably solid legal logic that explains the court's decision. However, you can't really shake off the feeling that this ruling actually sacrificed the climate in order to protect the formalities of the legal system. And that opens a new question. How actually important are the federal level regulations in the fight against climate change? So let's see what was happening between the walls of electricity power plants during those decades of legal discussions. In the US, between 2005 and 2019, emissions from electricity generation fell from 2,400 to 1,600 million tons of carbon dioxide. That's a 33% drop. This occurred mainly through the action of individual states and action by individual companies. In Germany, during the same period, emissions from electricity generation fell from 400 to 260 million tons of carbon dioxide. That's a 35% drop. And it occurred mainly through the combination of EU, federal and state regulations and actions by individual companies. So basically the result is similar. And that brings us to the question of the day. So do you think that the reduction of emissions in the United States would be even greater if new federal level regulation of emissions are implemented or are not implemented? For more environmental news like this, subscribe to the channel. Cheers.